I'm Charlie Pillsbury. I am co-director of Center on Dispute Resolution here at Quinnipiac. My other co-director, Professor Carrie Cass, is also here. We wish our training director were here, but Bill Logue could not join us. But we have the dean, so that's exciting. Whenever she can make time for one of these talks, but I also know that she and Professor Menkel-Meadow have known each other for a long time. In fact, this is not Professor Menkel-Meadow's first time at Quinnipiac. She's been here for Speziale symposiums, and I think for the opening of the law school.
In 1995.
Right.
1995.
Remember it very well.
So anyway, here she is today. She is a law professor at the University of California, Irvine School of Law, a founder of the dispute resolution field. A real honor to have her. Professor Menkel-Meadow came to UC Irvine Law School from Georgetown University of Law, where she was the director of the Georgetown Hewlett Program in Conflict Resolution and Legal Problem Solving. In fact, I think she introduced the term legal problem solving into the field. So appropriate, the center, I'm sure, which she named, includes that. Before that, Professor Menkel-Meadow was a law professor at UCLA for nearly 20 years, serving as a professor in the Women's Studies program, acting director of the Center for the Study of Women, and co-director of UCLA's Center on Conflict Resolution. As a Fulbright Scholar in 2007, Professor Menkel-Meadow taught and conducted research in Chile, Argentina, and China. An international expert in ADR, including international dispute resolution, the legal profession, the legal ethics, clinical legal education, feminist legal theory, and women in the legal profession. She has written and lectured extensively in these fields, including today. In fact, this is her second talk today. She was at the Yale Law School earlier for lunch, and now she's here with us, and I'm glad to say there are even more people here to hear her. And so good job. I'll explain. Actually, why don't we do that right before I just finish? One of the reasons that's true is that in addition to being sponsored by the Quinnipiac-Yale workshop series and the Center on Dispute Resolution, this talk here at Quinnipiac is being co-sponsored by Quinnipiac's Society for Dispute Resolution. Last I'll say about Professor Menkel-Meadow is because it's just impressive. In January 2011, she was the recipient of the first ever award for outstanding scholarly work presented by the American Bar Association's Dispute Resolution section. The ABA lauded her as a tireless, prolific, and influential researcher and writer who put forth the transformative idea of lawyer as problem solver 25 years ago. So the floor is yours, and we've talking for about
I'll make it half an hour.
35, 40 minutes, and then leaving the rest of the time for questions from our audience. Thank you.
Great. Thank you, Charlie. Thanks so much. And thank you all for having me back here. Very, very fond memories of when I was here in 1995. Nice picture in my office. So I know Quinnipiac, and I think of you very well all the time. So I thought I would just start by saying a few words about how I got into the field, since some of you may care about that, and then tell you how my work domestically in the United States evolved into international work, which is what my paper's about. And I'll try to talk for about a half an hour to leave time for questions, but I also want to invite you, if you have a question at any time that I'm talking, just raise your hand, because we in our field believe in conversation and dialogue, so I'd rather have you interrupt me if you want to say something in the middle of it, okay? So a long time ago, really a long time ago, when I was a law student at the University of Pennsylvania, I thought I was going to be a champion of civil rights, trial lawyer, win all those big cases, and make the world a better place, social justice. And so that's what I did. I graduated from Penn and I became a legal services lawyer in Philadelphia. And I love to tell the story about how I got into ADR, which might be of use to some of you, because I don't think it's, well, it probably is worse now. When I started as a legal aid lawyer, I had very quickly, within 2 to 3 weeks, 300 cases. And a whole variety of cases, very big national, eventually national class actions in employment discrimination, welfare cutoffs, Social Security disability cases, landlord-tenant evictions, unemployment comp cases, just unbelievable, and family law cases, child custody. And as is still the case, when you were getting welfare, the government made you sue the father of your child for child support. So I had to do a lot of child support hearings and contested custody cases. So some days I was in federal court trying to do some really big law reformy sort of case in a class action format. And other days, I was in the family court, very small, and supposedly very confidential. And I was surrounded by very good lawyers that were trying to train me. Imagine you're right out of law school. I had turned down a federal clerkship. I just want to say to all the students in the audience, follow what is meaningful for you and not what other people tell you to do. I'm very lucky to be here today because now to be a law professor, you sort of have to clerk, but I got a clerkship. I didn't particularly want to stay in the library anymore. I've been in the library all of my life. And so I became a legal aid lawyer right away. And so within 2 months of being in law school, I was in a courtroom. Unlike my classmates who went to big firms and were carrying the bags for somebody else. So I got a lot of experience very quickly the hard way. I didn't know how to ask. I'd never taken trial ad in law school. I didn't know how to ask a question. Judges were yelling at me because I couldn't conduct a cross-examination properly, so it was hard. But I was learning to be a good lawyer and work for social justice. In the back of my office, there were about, I think, 10 of us in a building in North Philly that was so dilapidated the plaster was literally falling on our head. And in the back of my office was a woman who graduated 2 years ahead of me from law school. And when a case came in, she interviewed the client, and the first thing she did was pick up the telephone and immediately talk to the person who was causing her client grief. A social worker, a federal agency, the school of the client's child, even a prison warden if necessary, if a family member had come in to complain about treatment in a prison. And I watched Linda. And she'd pick up the phone, and before you know it, she had settled the matter. No big class actions. So in the way we were evaluated as young lawyers, the people that were bringing fancy lawsuits in the federal court and winning would get, promotions and patted on the head and being told they were doing all the good things. And my friend Linda just quietly sat there and settled a lot of cases. So I did both. And fast forward about 2 or 3 years when the University of Pennsylvania asked me to come and help them start their clinical program. So in addition to all those other things that you heard, I'm sort of first-generation clinical professor and helped sort of create the idea of what a legal clinic should be. And the first thing I did was I said, we need to teach negotiation and problem solving. That's really where it came from. Because my mentor, she would never consider herself that. She ultimately became a judge later. This person, her job was to sit in the office and solve the problem for the client. And she was a social justice person too, so it's not like she'd forgotten about all the other things. But I had noticed, and so did she, that sometimes we would win those cases. It was much easier in those days. There'd be regulations and statutes passed, and you would do a failure to provide due process, equal protection, or a statutory challenge under federal law, and we win a lot of cases, pretty easily. But the underlying problem wouldn't change. And in welfare, where I did a lot of litigation, we would win some case on a technicality, and 3 months later, they would just redraft the regulations and go back to what they were doing before, just figuring out some way to, I guess that's solving a problem too. So it was from that I, in the clinic, started to teach first negotiation and then ultimately mediation. And I've always thought that this was an essential part of a legal education. And there are very few law schools in the country who take it seriously enough. So in a few schools, it is in the first year. In some schools, civil procedure is now taught with an ADR. That's why I always taught it when I taught civil procedure at Georgetown. It always had a very strong dispute resolution component. And I always started my first class by giving the students about 12 different kinds of disputes in the world and then asked them to design some process for resolving it. And, a few of them will wind up in court. But as I suspect everyone in the room knows or should know, the empirical studies, which are very clear now, say that only about less than 2% of all cases filed, both in federal courts and pretty consistently in state court systems too, actually wind up in trial. So I stopped teaching trial ad a long time ago. I taught it at UCLA for many years alongside of all of my ADR courses. And I decided I'll leave the trial teaching to the people who still love trials, but I just don't think they solve problems. So having said that, I became a teacher of negotiation and mediation, and I've now taught for a long, long time. And a result, really, of my domestic work, and ultimately, and your dean had the pleasure of doing it too, at Georgetown, we had a lot of LLM students who came from all over the world and were interested in what we were doing in the United States in ADR. And so it was really out of that work that my students at Georgetown, who were a little older, they were already lawyers, LLMs, so they were often government officials. I had someone from the Brazilian legislature in my class. I had a whole bunch of students that were working as congressional aides and going to night school at Georgetown. And I had students from Asia, South America, and Europe. And they took my courses because they were very interested in this stuff. And in almost all of those countries, even though mediation actually began thousands of years ago in China with Confucian principles and in Africa with indigenous village principles of mediation, all of these modern legal systems decided they wanted to learn about American ADR. And so starting in about 1998, I started to be invited to go and teach in these other countries. And the paper, did you guys read the paper or not? You know, this paper? So I'll just assume, you know, I'll do a little summary. Some did. Okay, that's good. That's the way it is with faculty also. So essentially, I've now had a lot of years of teaching in other countries, and I've been very fortunate to actually, most of the time, not all of the time, live in the countries too. So it's very important for me in this work is that I don't believe in the parachute in theory, which is what a lot of, when I lived in Washington, USAID and other international workers do to bring education and programs. People will drop in, do their little education, and leave. So in 2007, after about 10 years of teaching in other countries, I got a Fulbright, and so that enabled me to live for a while, first in Chile, then in Argentina, and then eventually to live and teach in a bunch of, I put it in the paper, I've actually lived in a place, probably about 25 different countries. Consulted for a few more, and I've taught shorter versions, but my paper is based actually on the places that I know better. Or best, just from at least, I'm not saying I lived there for a very long time, obviously. 25 countries is a lot. But I would say that represents, in most cases, being in the country for about 3 to 4 months at a minimum, and in some places much longer. So as a result of that international work, I've become kind of a trainer and teacher and professor of mediation processes and ADR processes in a lot of different parts of the world. About 2 years ago, I was asked to participate in a group, very fancy academic organization, the Max Planck Institute in Europe, because in 2008, the European Union passed a directive. A directive in the European Union is a law the European Parliament passes, and what a directive means is that within a certain period of time, every member of the European Union has to write laws in their own nation state to conform with that directive. The EU directive of 2008 said that every country that was a member of the European Union was supposed to come up with a program for trans-border mediation. So that in any cases where there was a dispute between somebody from one country and somebody else from the other country, they were supposed to provide for mediation services. And that directive also had, interestingly, because it's another field I work in, they had an ethics provision of the directive. And so every country was also supposed to abide by some pretty standard ethics procedures. In another thing I did in the United States, I was the chair of a commission run by the Center for Public Resources and Georgetown that attempted to promulgate ethical standards for mediators, arbitrators, and organizations, provider organizations that provide ADR services. Ethical issues like conflicts of interest. When must you disclose that you have a prior, past, or potentially future relationship with a party to a mediation? How much disclosure, how much should the mediator know or not know about the dispute? Can the mediator take a gift? That had become a big issue at the time. When the case is over and somebody's happy, can they give you a gift? So the European Union had actually, in advance of the United States, attached to this directive a set of ethical guidelines. I was very interested in that. So 2 years ago, I was invited to participate in a conference with both judges, I should say, not both, 3 groups, judges, academics, and lawyers from the European Union, a couple of countries in Asia, and I was the American representative, to talk about where mediation stood a couple of years after the directive. And that's what produced, in part, this paper. Because what we saw was, as the title of my paper says, there were some countries where there'd been pretty rapid uptake of mediation, and other places where there was a great deal of resistance. So I became interested in are there any factors that would help us explain why mediation is accepted in some places and not in others? So as we were talking before my talk earlier today, I just mentioned this problem of resistance and uptake is alive and well and living in the United States as well. I lived in California for a while, then I went to Washington, then I went back to California. The Northern District of California, which is where San Francisco is in many senses the birthplace of modern mediation in the United States. A person who actually grew up right here in Bridgeport, Gary Friedman, and was a very unhappy litigator in his father's law firm here, was among the first to start mediating family disputes after he had a very unpleasant divorce. I realize we're on tape. Hope Gary doesn't see this, but it's the truth. He would tell you the same thing. So Gary had a very unpleasant divorce, and he decided to become a mediator. And he trained an enormous number of lawyers and judges in the Northern California area. I joined the UCLA faculty in 1979, and I start giving talks about mediation, and people, lawyers, literally start throwing things at me. And they would say, why are we listening to a social worker? You know, we want to talk to a lawyer. And I would say, excuse me? And I would have to tell them. I tried cases for 6 years, really hard cases, and they just wouldn't see me that way. So, and LA still has, in my view, a somewhat resistant culture. Washington, like San Francisco, was one of the centers of the founding of the American dispute resolution movement. The federal courts there, two of the major national trainers in the country, Michael Lewis and Linda Singer, had also trained a huge number of lawyers in Washington, D.C. So I early on became a mediator in the D.C. Circuit Court of Appeals. That, as you know, is the court just below the Supreme Court. Really tough cases to mediate because, A, somebody's already won if they're an appellate court, so they have an attachment to their victory. And secondly, very sophisticated bar. So in other talks that I've given, I don't think I actually ever wrote it up, but it's probably in the footnotes of some of my published work. It was in that practice that I learned how clever the lawyers were who resisted, not officially, they had to come. Mediation was mandatory in the D.C. Circuit for a while when Harry Edwards was chief judge. People would have to come, but they would learn how to manipulate the process. So they'd use it as an opportunity to gain information from the other side, and then they wouldn't do much. And my very favorite case was a very major case involving federal agencies, which is the other reason it makes it very hard to mediate there. Starting in the early 90s, Janet Reno changed that a little bit. The federal agencies didn't have much authority for settling. So if they were in the Court of Appeals, they would come in and they would already have won or lost, but they didn't have any settlement authority. And I worked on a case in which I was very proud of how much I'd educated all the lawyers to work very well with me. And we were making progress on a multi-year complex case. And then the lawyers left the room to tell their partners at home what was going on. And their partners at home told them, don't you dare do that. And those partners held a press conference in their hometown, despite the signed confidentiality agreement that I had with all the parties in the mediation, and they denounced the mediation, and that was the end. So for you would-be mediators, and some of you are mediators, realize confidentiality protections protect the people in the room. They may or may not govern the behavior they should, but they don't always, of the clients or of the constituents. And so I noticed, and I got much more sophisticated myself, at how people can resist without necessarily lobbying against mediation rules. They showed up at mandatory mediations and then used them for their own purposes. So I just became quite interested in this. So when I got to the meeting in Germany by the Max Planck Institute, each of us made national reports from our different countries. And I was interested, trained as a sociologist before law, to see if there were any patterns in which countries were accepting mediation and which weren't. Because my own state of California, Northern California accepted it, Southern California didn't. I had my theories. You guys would be interested to know that my theory about Southern California was at some point in the, probably would have been the mid-'80s, I'll have to go check the dates, there were a lot of very famous movie stars getting divorced. Johnny Carson on The Tonight Show was getting divorced, and Joan Collins in Dynasty was getting divorced. And there was this media frenzy and trying to show how horrible their trials were. They were both slinging mud at their spouses. Johnny Carson eventually used a process which is quite common in California. It's an ADR process, and that is rent a judge. You can get someone who is actually either on the bench or a retired judge, and under rules that are protected in the California State Constitution, privatize your hearing, have the judge act like an arbitrator, reach a decision totally confidentially, but it still gives you the right of appeal. And so there was just a lot of acrimony, and it's LA, it's media land. The media wanted, like the whole fight conflict idea. And so that's my theory. I don't know that I ever wrote it, but I've spoken it in several places, that Southern California just had this, produced, I think, by the celebrity media vulture a culture that was different than kind of mellow, again, I'm about to engage in a whole bunch of horrible stereotypes. Much more mellow. I'd spent some time at Esalen, one of the New Age, facilities in Northern California, where a lot of meditation was being taught. But I think it actually bled over into the acceptance of more peaceful forms of conflict resolution. And so one state with two different cultures. And we were just talking here, New York City, believe it or not, where I grew up, if you hear my accent, a very conflictual, everyday society, actually also was one of the birthplaces of modern mediation. Federal judges really supporting it. Jack Weinstein using mediation in a lot of the big class actions and mass torts. So New York City, a lot of training in the Southern District of New York and Eastern District of New York federal courts. I did a lot of that training. So you have New York City and Washington, highly conflictual cities that have uptaken mediation and in fact made federal rules of procedure under the local rule authority. You have Texas, believe it or not. I'm going to come back to Texas in a minute. A culture that I will describe here as explaining a lot of other cultures, extremely litigious, right? Just as nasty as what I described in Los Angeles, but also an incredibly powerful parallel structure of mediation. Some of the founders of mediation, very, very strong. Eric Galton, Kimberly Kovach, these are all people whose articles you may or may not have read. And some federal judges, mostly Clinton appointees, who took this very seriously in the federal courts and also the state courts. Also, a lot of the mass tort litigators come out of Texas, and some of them liked trials, but I worked with some of them in the 1980s when I was a mediator in the asbestos facility that Harry Wellington, the former dean of the Yale Law School, developed. And the mass tort lawyers are an interesting mixed breed. Some of them want to go to court and get big class action settlements, and others of them know that the incentives for getting their attorney's fees and getting their clients some relief is to settle pretty early. So I got involved in some of the big mass torts of our era. Asbestos, Alcan Shield. I was an arbitrator of hundreds of cases in Alcan Shield. Do you know what that is, Alcan Shield? Alcan Shield's my era. Alcan Shield was this awful little birth control device. It looked like a fish. It was a little horrible wire thing, and you inserted it, ladies, in your bodies, and it operated with some weird mechanism to prevent implantation of a fertilized egg. It wound up causing a lot of pain, grief, false pregnancies, abortions, infertility. I was actually, I don't say this too often in public, but here I am on screen. I was arbitrating these cases when I was having unsuccessfully fertility treatment myself. So I've written about this. This actually is in an article in the Loyola Law Review, if you're interested, because I raised the question for myself, what is neutrality for a mediator or an arbitrator? I thought I was actually better able to judge these cases than any man that was doing it, because I was actually simultaneously, not from the Alcan Shield itself, but going through a lot of what the women were going through. So there's an interesting differential uptake within different aspects of American litigation, different states, different industries. The big pharma at the moment is interested in looking at early neutral evaluation and early neutral litigation because they know they get sued in class actions all the time. So I've been called by some of the big pharma companies. This is a system design issue. And these are all just illustrations to tell you, when I go to Europe or I go to Asia, they look to us as a model. They think the United States has become a model of ADR, and there's been a lot of uptake of mediation. And I say, we are a huge country, and so we have variable state cultures, variable legal cultures, variable industry cultures, and so we're variable. And that's really the thrust of my paper. As I listen to reports from different countries around the world, there are lots of different reasons for the uptake or the resistance. And so far as I can tell, I'm going to end give myself another 6 or 7 minutes. With some summaries, there are some patterns, and I'm just going to throw them out for you to, help me figure out whether you agree with them or not. But actually, I'm making the patterns up. I actually think it is very idiosyncratic. Factor number 1, as in the United States, a charismatic champion or leader. So Belgium and Holland both have very strong mediation cultures. At the moment, Belgium is a mess. I don't know if you guys know this. Belgium is about as split as Israel and Palestine, except nobody's killing anybody. And my good friend, Robert Mnookin, who teaches at Harvard and wrote a wonderful piece with my good friend from Belgium, has written that Belgium is 2 divorcing parents who won't get divorced because they don't want to give up the child, Brussels, and the capital of the European Union. So the Flemish and the Walloons are at each other's throats. They are, fortunately, unlike Palestine and Israel, pretty separated, totally. Different cultures, lots of complaints by the Dutch-speaking population that they are industrious. These are all stereotypes, right? Where they're the Northerners, the industrious people working really hard, and the Walloons, that's the French-speaking Belgians, are on welfare that we're paying for. All of these arguments will sound familiar to you. You've heard them in many parts of the world, but they're having them. And yet there's a very strong culture of trying to use mediation in the court system. Why? Champion. A couple of unbelievable judges, many of whom in the good part of Belgium who've worked all over the world. As you may have noticed in the refugee crisis in Europe right now, if you get to see on the news, as I do when I travel, other countries cover this better than we do. A disproportionate number of the aid workers working throughout Turkey, Greece, and now Eastern Europe are Belgians. They've always had a very strong social welfare, like me, social justice, social welfare in the world, and a lot of Germans. So a lot of the people working internationally on the refugee crisis. So you could say there's some cultural something, but Belgium also is the colonial power of the Congo. Did lots of really nasty bad things. So you can't say there is a Belgian culture. In Belgium, I would say it was the authority of some very charismatic judges who believed that this stuff was really important. And one thing I will say right away is Europe, as some of you may know, is a civilian as opposed to common law system. So one factor for uptake, when Belgium and the Netherlands, also charismatic judges, and by say charismatic, they're not flashy celebrity types. These are extremely polite, quiet. One is a woman judge, and the other is a male judge, former head of the Cour de Cassation in Belgium, very devoted to ADR. They believe after years of judging. Like I came to it from being a lawyer, they came to it from being judges. This is a better way. And when I say charismatic, they're quiet. They're not big personalities, but they're very persuasive in their countries. These countries pass laws because in civilian countries, everything is codified. So one factor in the uptake is a legal factor. If someone thinks this is a good idea and they are either a judge or a legislature, they can make it a good idea by putting it into the law. Common law systems like us, like the US, Australia, Canada, and the UK, in my paper I describe as cultures that are both argumentative, we argue a lot, and adversarial. We're used to having trials and we're used to arguing about things. And we also have parallel ADR movements. In all of those countries, Australia very strong, US, Canada mandatory in the province of Ontario, also very big in British Columbia. I was there in the spring lecturing and there's a lot of ADR activity in British Columbia. The UK, complicated story, but basically our cultures can have this going on simultaneously because of the legal culture we're common law systems. So the federal courts can make a local rule, thou shalt go to mediation, and then people go to mediation, and then they complain about it. So many years ago I wrote an article about the co-optation of ADR processes by the courts. And so throughout the country there were different cases saying you cannot force somebody to go to mandatory mediation. You cannot make somebody bring the corporate officer to a settlement conference with authority to settle because that's not our way. And different courts in the United States have come to different conclusions. So with a common law system, and that's true for Australia and England and Canada, we can make rules, but then you get all these little variations by people challenging things in the courts and the courts modifying the rules, such as they are statutory or civil procedure rules. In Europe and in Japan, which is also civilian, and China's a hybrid, you can enhance the uptake of mediation by simply passing a law, and it becomes the law. So in Europe, all of these countries, because of the directive, have now had to pass laws on mediation. And I don't know how many of you studied international law, but we have a very interesting example of international law in the uptake of ADR. The European directive, remember, says, thou shalt have some mediation rules for cross-border disputes. Well, a few countries have used the European directive to become what we would call, in international law, monist states or unitary states, saying that our adherence to international law will automatically become part of the domestic law. So some of the European countries have said if we have to agree to mediation in trans-border disputes, we're going to pass some laws that say we need to use mediation nationally as well. And other jurisdictions, we are one of them, in the world are dualist in international law, meaning we sign treaties all the time, and also we don't sign treaties a lot, and they don't automatically become part of our law until the Senate ratifies them. And then they may actually, in some cases, need further implementing legislation to become the law of the land, despite the supremacy clause and what you may be learning in international law or constitutional law. So in Europe, some countries use the directive to become monist states, to say if we're going to mediate trans-border, we're going to make laws that say we have to mediate in our country as well. And other countries said, all right, we'll promise to mediate Belgium with Holland, but we're not mediating with the Germans. Or we're not, with ourselves. And the Germans have said that. We will mediate trans-border, but we're not going to force anybody to mediate inside our country. So there's a lot of different space for experimentation in legislation. The European countries, though, tend to do it by statute and legislation, and they can choose one way of resolving disputes nationally while still choosing another one internationally. Now, I want to quickly we'll leave time for questions, tell you 5 different stories.
5 more minutes, whatever you need.
Okay. I want to just tell you 5 different stories. This is my take on the variations that I've seen, and then spend a little bit of time talking about one of the jurisdictions. So I listened to the Europeans talking about their differences, and I have taught and spent a lot of time in South America, excuse me, parts of Asia, and a good part of Europe. And there are no really obvious patterns, as I've just said to you. My cultural patterns start with 2, argumentative and adversarial. Well, we're argumentative. That's our media, telling stories about everything, and our fight, and our being comfortable with a certain amount of conflict in our society. You think we're bad. The Brits, who you may think of as being very polite, if you've ever watched the Parliament, right, on TV, they yell at each other much more than we do. Not this, and I cede to the woman from Connecticut. They actually yell at each other. So England is used to a fair amount of argumentativeness. You think that we or the Brits argue a lot, go to Israel. Everybody argues all the time. It is totally acceptable to argue and discuss things. And so does Italy, right? I hear in here probably some Italian Americans in the audience, right? Voluble societies. And I spend time, right. And I spent a lot of time in Argentina, where a large part of the population is Italian Argentinian, huge. It's not like a lot of other countries. Argentina is actually very similar to us, a very European immigration. So, a good part of the population is Italian in derivation, also Spanish, and not that big an indigenous population as you would find in other parts of South America like Brazil and even Chile or Peru. So argumentative cultures, as I've told you before, they're one strand. And argumentative cultures, as I've just said to you, they can have both. Argentina has had a huge uptake of mediation. Why? Because, following my first factor, a very charismatic judge many years ago, Gladys Alvarez, she's amazing, went to the Harvard program on negotiation, on a judicial training program, and fell in love with getting to yes, like a lot of us did, and decided this was a better way. So she went back to Argentina. She taught herself English so that she could read all the early ADR texts. And many years ago, probably before I came here to Quinnipiac. In the early 90s, we were both getting awards in New York for ADR activity, and she had been the single innovator of mediation in Argentina, founding a group of things called Casas de Justicia, houses of justice, and she took the whole idea of mediation into the courts in Buenos Aires and then out to the provinces. So I was just at Tierra del Fuego in January on my way to Antarctica, and I went to go visit the Casa de Justicia that's in Ushuaia, which is the southernmost city in Argentina. There's a mediation center there. Amazing. So argumentative cultures are used to people talking about their problems or talking about their issues. And Argentina has the largest per capita population of shrinks. And so people argue, and they're used to expressing themselves. As opposed to, in my paper, I talk about when I first got asked many years ago to go do some training in Norway. Everybody was extremely polite. Yes, Professor Menkel-Meadow. They did the simulations. They did all of this. Everybody was very nice. And I went home, and about 2 years later, I asked my friend who had invited me and where I had lived with him in Oslo, a professor at the University of Oslo, what's going on with mediation in Oslo? Nada. Why? Formal culture. Everything still has to be notarized, very formal, and you'll be interested to know that in the European Union procedures, a country may take itself out of the directive process. And Denmark, of all places, said, we're not going to be part of this European mediation directive, right? Probably countercultural to what you might expect, that the Danes are very reasonable, and of course they would mediate. The Danes said, we're not having any part of this. Again, formal or informal cultures are part of it. So adversarial cultures, that's us with our adversary system, but also a good part of Europe still has the inquisitorial system. It's still adversarial, that facts are presented by oppositional people. And some of those cultures maintain the idea that the inquisitorial system, where the judge develops the evidence, is sufficiently in the middle that they don't need any mediation. So some inquisitorial societies have been a little slower to uptake and a little bit more resistant. Third broad base of culture, face-saving, or as Laura Nader likes to call it, harmony cultures, cultures that say it's wrong to have conflicts. And stereotypically speaking, this would be China and Japan. People say Asian cultures, preservation of family, preservation of group, the individual is less important, so mediation is going to be very strong there. That is both true and a myth. So Chinese mediation, thousands of years old, based on Confucian principles, but used by Mao and the communists as a form of political education. So there was little litigation during the Mao regime, and the idea was you had to resolve your disputes. And I have films that I show my classes of mediations that happened in China during the early period of communism, and it looks a hell of a lot more like arbitration. Thou will do this, thou will not do this. Indeed, interestingly, since we just heard this morning that the one-child policy has been revoked, many of those mediations from the early years, they're horrible, were wives accusing their husbands of killing their girl babies. In the early days of the one-child policy, mostly in rural areas, but also a little bit in urban, when a mother gave birth to a girl and everybody wanted a boy, the fathers would figure out ways to leave them in the field or to suffocate them. And sometimes the mothers did it too because they didn't want to lose their husbands. So these went to mediation, not to murder court, not to criminal court, but these went to mediation. And so it's an odd thing that people would say this is a face-saving. Yeah, it is harmony with the Communist Party or harmony with your family, but it's actually something we wouldn't recognize as mediation in a facilitative sort of way. Japan is known as a country that has a lot of mediation, and here I want to use Japan to say another variation is sectoral. So Japan has always used mediation in family disputes, and many countries use mediation in labor disputes because they don't want any interruption of the workforce and the relationship. But because of a lot of other developments, the Japanese actually, especially particularly environmentalists in Japan, have actually been beginning to litigate those cases a lot, and they are not being mediated. So there can be sectors, certain fields. So mediation is commonly used in family and labor pretty much around the world, though in some cases the labor mediations look more like arbitration. otherwise known ironically as conciliation in most countries. They use that word, which sounds softer. In labor conciliation, it usually means if the parties don't come to an agreement, the conciliator decides for them. So the face-saving harmony cultures, it's sort of a stereotype. Sometimes it's true, sometimes not so true. Next culture that's very interesting are hybrid cultures, or I like to see new cultures in transition. So my lunch talk at Yale was about transitional justice, which is going on all over the world in post-conflict settings and in new countries. So post-apartheid in South Africa, post-military dictatorship in Chile and Argentina, Liberia is another place, of civil war, Sierra Leone, attempts to prosecute the Khmer Rouge regime in Cambodia. These are countries, old or new, that are creating new legal systems. And what you find in a number of countries, Ghana is one in Africa, that has mediation in the law. The creation of new courts and the creation of civil procedure, but also there shall be mediation, it's in a statute. And so hybrid or new cultures are also trying to have both, but by starting from scratch, recognizing we're starting a legal system a little bit later than a lot of other countries. What have we learned from those countries, and can we have a hybrid? And then my final example, and I'll just say a few words about Singapore and then I'll take some questions, is what I call cosmopolitan cultures. Now these are cultures that, like some of the others that I've described, may have both going on. Both formal litigation and alternatives, but they've embraced it. And so the two leaders of this actually, ironically, are Singapore and Shanghai. These are new economies, China a very old country, Singapore a relatively new independent country, post-colonial. And both of these countries have established new ADR centers, and what they're hoping to be is the center of international commercial dispute resolution. And I teach in Singapore every other year. The beauty of Singapore is it has a brand new, like you guys, brand new modern building that's downtown, and that building contains both the Supreme Court and the Singapore Mediation Center in the same building. Now what's interesting is people in Singapore tell me, be careful what you see, because the Singapore Supreme Court still follows very much British precedents, still very much a post-colonial British legal system. And the Singapore Mediation Center is being used in two ways. One is to become a center of international commercial other ways of resolving disputes. So both mediation, and they also want to become an international arbitration center. That's what Hong Kong is. Hong Kong has become pretty much a good center of arbitration in commercial relations. But when I was teaching in Singapore, it was very interesting that a dispute went to the Singapore Mediation Center. The dispute was that ethnic Indian and ethnic Chinese families were fighting with each other in their housing building over the amount of curry that they were smelling. The Chinese were complaining that the Indian family was using too much curry. Now, any of you who've had any food from China or India know there's curry in both cuisines. So this big dispute went to the Singaporean Mediation Center. And what was interesting, because many people will tell you Singapore is a very authoritarian, autocratic country. It had one leader for 40 years who just died recently, and now his relatives are in the government. And what was extraordinary was it was announced on the news that the Mediation Center had decided, SIC in my paper, right? Mediators don't decide anything. But it was announced that the mediation decision was that the families would divide up the day from mediation sharing, right? So that cooking would only occur during these hours and non these hours. What then transpired was truly extraordinary. There is a Singapore citizen webpage for the entire nation state. It's a small country on small amounts of land, and a huge amount of the population lives in the main city, but there are some places around. And while I was teaching there, thousands of people wrote comments on the webpage about what they thought about this mediation. And most people said it's not about the curry. This is about the in-migration of Han Chinese from the mainland and from India working on our booming economy. And so this dispute is really about how people are going to live together multiculturally. Now, Singapore has an amazing thing. they have quotas. A huge amount of the population, I would say something like 80% of the population, lives in huge, very, very tall apartment buildings. And a good number of them are state-owned. So it's a weird combination of socialism and some would say fascism, I would just say authoritarianism. Everybody's guaranteed housing, that's the socialist part. And the authoritarian part is every one of these housing blocks has a quota by ethnicity. No more than 75% Chinese ethnic, 15% Indian ethnic, and 10% Malaysian ethnic. These are the major ethnic groups, and then a 5% other. Why? Because it was mandated by the government, you shall get along. And we are not going to have ethnically segregated housing. And I will just say, and I'll stop there, that I think that's an interesting example of what hybridization and complex cultures can produce. Now, I don't live there every day, but I have lived there a lot. I lived there close to a year when I put it all together, and I think it works. So the question is, having said all that, am I arguing for some cultural determinism that says you have to be in one of these groups for mediation to take off? No. I just think it's interesting to observe in the places where mediation has taken off, what produces it, and then what are some of the, if you were using aviation imagery, what are the fast winds and the back winds and the tailwinds? There are factors that can move the uptake of mediation forward, like legislation and mandating it. I now believe in mandatory mediation. I didn't when I started. And what are the things that can prevent it from happening? Clearly, and I'll stop there, champions, people who really care about it and believe it is a better way to solve problems is one of the answers. But I would just add, my scholarship in the last 15 years has been about process pluralism. I believe that negotiation and mediation are better ways. They're not the only ways. And so I think most of these systems also have to leave some space for places where mandatory court orders and mandatory actions by the government, sometimes for policy reasons to do the right thing, are also necessary. I'll stop there. Questions? Comments? Yes?
Thank you very much for coming. That was a really very nice talk. My question would be, when you were talking about the different international bodies in Europe that have been using or introducing mediation, I wanted to know how much in recent years training for mediation and ADR has picked up in places like European Union or Council of Europe, of course, not to be confused
Right.
with European Union and the European Parliament as well.
Great question. And the answer is, it varies. I have a lot of,
Repeat the question, I'm not sure.
Okay. The question was how much is training increased in the European Union, and not to be confused with the European Council. Everybody know the difference? European Union is 27 countries that have formally signed a variety of treaties and are supposed to be a unitary, complicated government. Take European law, European Union law if you're interested. It makes our federalism look like a piece of cake. The European Council is much, much bigger. So other countries are in there, and how that's relevant. The European Council is the group that signed the European Charter of Human Rights. So that's the Strasbourg Court, and that court rules on your European your human rights issues, which includes Turkey, for example, which is not in the European Union. So there have been lots of issues about minarets and veiling and headscarf, big issues. That's the European Council, and the Strasbourg Court, that's different than the European Court of Justice, which is just for the members of the European Union. And the answer is, both of these bodies are interested. They've done lots of training. I have a friend who is a barrister who litigates a lot in the Strasbourg Court of Human Rights. And the human rights courts, both the European Court and the Inter-American Court, which is in Costa Rica, have a procedure called friendly settlements. And those are intended to produce negotiated settlements. The European Union has not been using them that much. There's a whole book on it if you're interested. The Inter-American Court has been using it more. And I was asked a few years ago to go to the OAS in Washington's office to help them talk about how to promote it more. So I think we're right at the beginning, not the super beginning, but the beginning of of these institutions recognizing it. Now, I'm glad you raised the question because it gives me a chance to say two other things that I forgot, which is people come to ADR for two different impulses. And one is what I've often called the quantitative docket clearing. Like, we have too many cases, let's move them to mediation. And that's what former Chief Justice Berger was suggesting in the United States. Too many cases are coming to the Supreme Court, they're bothering us. Get them out of the federal court. Oh, mediation, what a good idea. Let's have mediation for all those cases we don't want to deal with. So some countries that have big caseloads turn to mediation for that reason. And that's what's being talked about in the European Court of Human Rights. We just have gazillions of cases and we can't manage them. Maybe we should take a page out of the ADR case management idea and try to settle more. I come at this from the qualitative argument for ADR. ADR is better because it produces better outcomes. When people have a role in crafting their own outcome, you ADR students would all know this, it's consensual. You have a role in the outcome. The outcome can be future-focused, which a court adjudication can't be. So I'm more interested in the places that are picking this up for qualitative reasons. And the European Court, in my opinion, so far, has been motivated mostly by the quantitative, we got to deal with these cases. Why? Because most of the human rights lawyer activists are resistant to mediation, right? Imagine you're dealing with human rights. Those are the civil rights lawyers that I used to be one of here, very principled. We have to win in the court and have a court ruling that says this is wrong, this is bad behavior, stop doing it. We're not settling or compromising with anybody. So some of the resistance comes from the lawyers that work in the system. In the Inter-American Court, it's very interesting. When I got invited to go to this little meeting, consultation at OAS, I could feel the tension in the room. And you guys are going to laugh at me, here we are on tape. It was very gendered. In that room were a number of my former students from Georgetown that have worked in South America, one of whom lost her brother in Argentina as a disparecido. And she wants justice. This is a woman who went to law school, came from Argentina to the United States to go to law school, to get justice for her brother. Not just in Argentina, but she wanted the U.S. punished for their complicity in all of this. And she was now sitting in this room, and she's so open and saying, I think in some situations, settling might be a good idea. So they were looking to recraft their friendly settlement rules. So the European Union is training people, and my barrister friend has retired from litigation and he wants to be a mediator in the Strasbourg court. So he's taking every training course he can, both in the UK and in Europe. As some of you know, just like in the United States, there's a very big training business. So you may or may not have read about this organization, the International Mediation Institute. It's immediation.org. Am I getting that right?
I think it's IMI.
Thank you. IMI, yes. International Mediation Institute or something like that. Just put it in. And you'll see that they are doing a lot of training, and their little attempt to be a market niche is to certify people with cross-cultural competency. So you can pay a lot of money and go there and get trained in cross-cultural, which I think is important, absolutely important. Although I'm a great skeptic about how you can actually teach that to people that don't have it. But you will go to their training programs, and then you'll get stamped and you get put on. I think they were going to put me on the list. I get grandmothered in, right, just because I'm one of the, quote, founders of the field. And my parents are European, and I only speak one language, but I understand a bunch. And so you're absolutely right to ask about the training. I worry about it because just like I told you that Europeans do things with civilian codification, I'm glad you mentioned, at this Max Planck meeting, I and the Brit, my friend Hazel Gann, who's the dean of the University College of London Law School, both of us refused to sign, there was in European style, we were going to sign some big document on the importance of regulating mediation so that it would be done properly. Right? Thou shalt go get good training, and only when you're certified by your country should be a meeting. And as common law people, and as people that were at the beginning of our movement here, which was intended to be a little bit more inclusive, Hazel and I wouldn't sign this document. So the answer is yes, there's training, there's and the European Union and the European Council are thinking about it. But they're having to deal with multiple country cultures. And then I would say, can I say this sort of old-fashioned, I'm an American, I can say that, old-fashioned European notions of who gets to be a lawyer in our very proper institution. There's still a lot of that. It's changing, but there's still a lot of that. Yes?
You mentioned that you used to not really be, or not really accept mandatory mediation, but your mind has changed. What changed your mind?
That was really easy. The question was, since I said that I used to be opposed to mandatory mediation, some would say an oxymoron, right? Mediation is designed, at least theoretically, to be a voluntary process. And I said I changed my mind. And that came very easily to me in one case. As I mentioned earlier, I was on the list to be a mediator in the Harry Wellington Asbestos Claims Facility. The asbestos claim facility in the 1980s was not about plaintiffs and defendants. The cases in that facility were, at the very early period of mass torts, allocations between the defendant companies that were getting sued by plaintiffs for having asbestos, all the manufacturers, Johns Manville, who went into bankruptcy from it, Celotex, all these big construction companies. And the facility was resolving disputes between the manufacturers and their insurers. It was very big here in Connecticut, as you know, the nation's capital of insurance. So that's probably why Harry Wellington, dean of the Yale School, was so involved. So all the insurance companies came together and decided to have this settlement facility. It was a very big deal, in which they decided that the insurance companies would tax themselves, the first time the concept was used, by market share. So by their market share of insuring asbestos-producing companies, they put money into the facility, and then as the claims came out from the plaintiffs' lawyers, they would then pay them off. So the facility I was a mediator in didn't have to do with the plaintiffs, but the fights between the companies and their insurers about what the insurance policies had agreed to cover. So I mediated for 2.5 years a $1 billion dispute between 2 manufacturers and 5 insurance companies. That's how I got into multi-party ADR, which is a whole other topic for another day. But having done relatively simple, either 2 parties or 2 parties and 2 lawyers, 5-way meetings, now I had to manage a room of 30 lawyers and a whole bunch of financial people. And they came to me. Why'd they come to me? Because I was a girl, I'm sure. And I'll tell you a story about that. And I was relatively young. This is a while ago. And they were just going to mediation because they had to. Because the Wellington Agreement said, thou shalt go to mediation first. You must show up for mediation, because Harry Wellington had been sold that this was a good thing to do. You must go to mediation before you can proceed in the rest of the proceedings. So I think, I was at UCLA at the time. They picked me off the list. She's in Los Angeles. It's the winter. We'll go, we'll show up for a couple of hours and we'll leave. And I think that was my most successful mediation ever. I mean, the case didn't settle. I'll tell you what happened. But it's all in the news, or I wouldn't be able to talk about it. But most successful in the sense that I took a bunch of very hard-nosed litigators who thought they were just showing up for a condition precedent, and 2 years later, they were still there. And that's why I became in favor of mandatory mediation. We were very close to a settlement. And the mediator's always the last to know. We were about to sign a settlement. I remember very vividly, just as I remember vividly my day at Quinnipiac 20 years ago. I'm driving in my car in Los Angeles, and I hear that one of the companies that was involved in this mediation has just filed for bankruptcy. The mediator is the last to know, and I know in that moment there's going to be litigation about fraud. Because those people, 3 weeks earlier, were sitting in my mediation exchanging alleged financial statements about what their insurance was and how much money they had to pay. And sure enough, those of you who are mediators are going to be mediators. I keep up my malpractice insurance because I had a feeling I was going to get subpoenaed. And if you have the right policy, your mediator insurance policy will pay for any court appearances that you have to make, because I was going to be one of those people going to jail. In contempt, because I wasn't telling nobody nothing. What happened in this room stayed in this room. I had confidentiality agreements that signed that, but I knew the company that had been lied to was going to take it up in bankruptcy court, and they did. And they called me, and I said, I'm not testifying, and I was very lucky. They left me alone. Nevertheless, every one of the lawyers, and that company emerged out of bankruptcy, and I drive around and I see their trucks all over the place. And the interesting thing was I'm very angry at the lawyer, who I knew they couldn't possibly have been mediating with me and then filing for bankruptcy 3 weeks later without having prepared their bankruptcy pleadings while they were doing all of this. So that's a whole issue about fraud in mediation. What can the mediator do? Not much, if anything. But every one of those lawyers, even the bad guys, for the next 10 years, they would call me up. I didn't mediate with any of them ever again, but they would call me up and they would say, I have a dispute in this part of the country. Can you get me a mediator? I have a dispute in that part of the country. Can you recommend somebody? They were persuaded. So as a teacher, that was my best job of teaching and my best mediation, because they decided it was a good thing to try. And so now I believe that everybody needs to show up in the room. It may be a terrible experience. It might even add a little expense, which is why some people don't like. But you'd be surprised how even the most resistant person can sometimes be brought around. So that's why. Now, I realize in a lot of small claim settings, and it's terrible. And I will tell you that years ago, I had a small claims matter in San Diego. And San Diego has a rule that lawyers can't appear in small claims court. So I appeared, I'd filed this complaint of some little consumer thing, and I don't know how the judge found out I was a lawyer. I don't think I said anything. And the judge said, you can't be here, you're a lawyer. And I said, excuse me, this is my case. I know I'm a lawyer, but this is my case. And then he said, you have to go out in the hall and mediate. And I said, you don't know who I am, Judge, I said, but I'm one of the founders of mediation, and I am not mediating this case. I am just here to get a judgment for my $100 so I can go execute on it in this little stupid store that's annoying me. I said, no, you're not, lady. Go out there and mediate. So the mediators actually were law students from University of San Diego who did know who I was once I said my name. And so they were a little intimidated, and we all agreed that we would go through the motions of mandatory mediation, and I'd go back into the court. So yeah, I realized lots of abuses, and small claims is one of those where it can be a problem. But I actually believe that it's good for everybody to have to go in any kind of case. And I say that knowing the other big place that's always been controversial is in domestic violence cases. So if you haven't read it, my favorite article, my friend, Lisa Lehrman, professor at Catholic, who is a big women's rights advocate, as was I, she did a wonderful piece saying, I'm against mediation in domestic violence cases. I'm really against them. But if they're going to happen, this is how they should be done. So that's a place where caucuses are appropriate. The person who trained me, Gary Friedman, is the national expert on never caucusing. That's his model. Never, ever let the people get away from each other. They are here to negotiate with each other. And Lisa's piece, it's in the Harvard Women's Law Journal in one of the, pretty early. And I think it's a really thoughtful piece because it says, in general, this could be a place of great danger, but many courts are going to require it. And in some cases where there's some potential possibility of therapy, treatment, and keeping the family together, it makes sense. Here are some protective ways of doing it. So that's the other thing I want to say. Mediation itself is variable. And so whether it's taken up or resisted depends on how it's done. And so, well, I'm on a roll on this, but I just want to say another thing about the asbestos case. Another one of my favorite stories. So I think actually in the middle of this big asbestos case I was doing, I was at a CPR meeting in New York, and Harry Wellington was there. And it turned out that I was doing $1 billion is a lot of money. I was doing the primary layer of insurance. And little known to me, Harry was mediating in London, in Lloyd's offices, the secondary and tertiary layers of insurance of pretty much the same parties that I had. And he said to me, it's going really badly for me. And they all tell me that they're having a great time with you in California and things are really moving on. Why do you think that is? So this is another thing. Have I ever proven this empirically? No. But Harry and I had this great conversation for about a year during that period. And my hypothesis, which I now use when I'm training people, is, I told you, they came to me because they thought I was a young professor in California, totally non-threatening, right? And so they actually started talking to each other. What happened in Lloyd's of London? Mahogany, dark wood, super fancy building, Lloyd's of London. Harry Wellington, dean of the Yale Law School. So they were all trying to impress him. And their surroundings made them be very formal, and to show they were good lawyers, they were going to keep arguing with each other. I was in California. We had a meeting a month for 2 years. Once a month, these lawyers, 26 or 8 of them, a lot of them, flew into LA and stayed in a lovely hotel in Westwood. And after our 4th meeting, the hotel started to send me free bottles of wine. Because remember, I'm bringing 30 fancy lawyers in to stay in their hotel. They're making a lot of money from these guys. And so I thought a lot about a question that Carol Liebman, our colleague, has now written about, the role of food in mediation. Because I'd have to cater long meetings, but I thought a lot about this liquor question. It's very complicated. It can cut both ways. Because when people have too much to drink, the inhibitions go down, and but actually this hotel taught me it was just perfect. They just sent, I think, like 2 bottles of wine. Everybody had a little glass of wine, no more than that. And I actually think, and then in the breaks, when I had caucuses, those big nasty, and some of them were very nasty lawyers, they went out and they took a swim. So I also think the setting had a lot to do with it. So we're talking about gender and whatever, and prestige of the mediator, so that they were much looser with me because they weren't trying to impress me so much. Therefore, they could talk to each other, which is what they were supposed to be doing in the first place. And the setting and the food, it just, that's why companies and institutions take retreats you get away from where the conflict is. And so I think moving into a fancy conference room at Lloyd's actually made it worse with the dean of the Yale Law School. Now, you could just say it was the money because he was dealing with higher levels of reinsurance and so it was billions as opposed to $1 billion. But I actually think it was some of those things. And I say that because for many years I did training for the D.C. Circuit Court of Appeals, where I was a mediator. And that's the last Circuit Court of Appeals which still has volunteers. All the other courts of appeals in the federal system in the United States now have staff mediators. So that's a job thing for you guys. You can't move right into it. But after a successful practice of some kind, either as a mediator or in litigation practice, you can have that job. And the Ninth Circuit has the biggest. There's something like 20 full-time mediators in the Ninth Circuit. But what was sort of interesting, when I was training the D.C. Circuit mediators, most of those people were extremely prestigious Washington, D.C. lawyers. Very. 2 of them were my colleagues at Georgetown, very fancy lawyers. And to bless their heart, one of them, who is a very well-known lawyer in Washington, D.C., told me, I really heard that story, I told that same story, that you've told, Carrie. And he said, I am not mediating either at Georgetown, where a lot of law students don't like to go back to where they went to law school, like, traumatic stress syndrome. And I'm not, not here, I know that. But in other places they do. So, nor, he said, am I going to mediate in the courthouse, because from what I heard you saying, that's going to just make all the adrenaline go up and have people think they're litigating. And I think I'm going to tell people to call me Mike rather than Professor X. A great student, a very wise man. He learned. And so he showed up for his mediations without a tie, without a suit. He found other places to do them. And he's a brilliant guy anyway, but he was very successful. My other colleague, who's world famous, now departed, didn't change a thing. And he would come to see me and say, my cases aren't settling, Carrie. And I would say, also a very tall guy, right? I'm short. Can't change that. But I would say, just ask yourself, what are you doing in the room to heighten the conflict rather than to provide a safer space for? So I think that stuff matters. And so that's the hard thing about training. You can train people with all the active listening and so much of it, I think, is your presence in the room. And so ironically for mediation, some of the most successful people in life, cabinet officers, ex-presidents, Jimmy Carter thinks he's a mediator, ex-presidents, some of that, it may work in some settings and it's absolutely detrimental to other kinds of processes. So there's power for us, less powerful people in this work, I think. That's what I like doing. I just say, you've heard me say that why I'm in favor of mandatory. It goes to the teacher in me. I use what I am, a teacher. So when people come into a mediation room, I say, we're all here to learn together how to resolve this conflict. And I have no trouble being a little schoolmarmish. That's who I am, and I use it. So sometimes it works. But I believe in teaching people. Even if you don't like it, here, have some medicine. Yes?
So this sort of jumps off your question, going back to the idea of training in these huge, important legislative and legal bodies in Europe. If and how have you seen mediation work or not work in United States lawmaking and policymaking? AKA, can the United States Congress mediate?
Oh, one of my favorite. All right, so two
Just repeat,
things.
that's a question worth hearing again. Just so
Yeah. Oh, well, I mean, I'm happy to stick around. So I have a couple answers. You guys may be too young to remember, but I was in Washington when Newt Gingrich took over. So Bill Clinton was president, 94. And interestingly, a group of mediators decided this was going to be a disaster. So they went off and did this thing, you can read about it, the Hershey Retreat. They took the congressional leadership to Hershey, Pennsylvania. Yep. And stayed in some very nice retreat setting that's there. I was not there. This is just reported to me. And they did a whole bunch of, what's done in the construction industry, partnering. So they did a whole bunch of partnering exercises. I believe that Larry Susskind from CBI was there. I'm not sure, you'd have to ask him. I forget how, I know this from living in Washington. And everything was great. And everybody signed well, not signed, but shook hands and said they were going to behave better, 1994. And the minute the first vote came up, disaster. So in all my years of Washington, people would say to me, do you want to do that? Do you want to do some training? Do you want to talk to them? I did a few talks and I said, my husband's a political pollster. So I knew just how divided everybody was. And I thought that was bad. Gingrich passed a whole bunch of bills with Bill Clinton. You may recall the government shut down. Some of you old of us to remember, the government did shut down during Clinton's administration. That's when Monica Lewinsky did her dirty deeds or whatever. Or the president did, whatever. But in any event, after that ended, they actually passed a fair amount of legislation. So it's much worse now. The second story I will tell you is one of my best students at UCLA many years ago went right from UCLA Law School to work on Congress, where he remained for a very long time. He's not there anymore. But when Hillary tried to do her health care plan in 93, he was working for one of the Congress people that was very actively working on the health care plan. And he called me up and he said, Carrie, everything you taught me, getting to yes, does not work here at all. To the extent there are any trades, they're log rolling and I'll sign your bill for my bill, there's no principled negotiation going on here. So every year since then, that was 93, 94, I've told every one of my classes, if somebody can write a paper about how we can get Congress to mediate, you get an A. So if you can think about that. I mean, I've spoken to a whole bunch of groups. It's just horrible. I actually think, take the worst conflict, I work in Israel and Palestine. Take the worst conflict in the world. I think those are more solvable. And the reason is, for a concept any of you who've taken negotiation have studied. I keep meaning to do an op-ed, but I keep forgetting. Reactive devaluation. You label a bill raised by the Democrats, and the Republicans will say no. And I don't know if you've read Lee Ross's famous study. You guys know what I'm talking about. Lee Ross is one of the person who actually came up with the idea of reactive devaluation as a social and cognitive psychologist at Stanford. And in the early 90s, when the South African boycott issues were alive, and students were demonstrating for universities to divest investments in any country that had any company that had any business dealings in South Africa. So we had a tent camp at UCLA, and Stanford had a big one. And Lee Ross used this as an opportunity to test his theory, which was, there were three proposals. Divest now, student proposal. Gradually, we have a fiduciary duty on the board. We can't just drop all these stocks if they're going to decrease the Stanford endowment. So divest gradually. Which was identified in his proposals with the faculty, but in fact it was the board that had done that. And the third proposal was the administration, and the administration proposal was, no, we're never divesting because, that's irrelevant to our financial decisions. And he took those three proposals, the substantive proposals, and he labeled one student, one faculty, one administration, and then he mixed them up. Did a matrix of 9, and he went to different classes and asked them to vote. And what happened? The students always voted for the student proposal, even if it was don't ever divest, when, at least as of the spirit of the school, most of the students were the ones promoting one. That is an empirical verification of reactive devaluation and labeling theory. That we vote for the things that we think are ours or belong to our people, our tribe, our party, whatever. And I always say, I think Lee Ross, he should have gotten the Nobel Prize. His colleagues, Kahneman and Tversky did. Tversky didn't get it, he was dead, but Kahneman got it. These guys all worked together. I think that's the single most important concept in human history lately, reactive devaluation. You don't hear an idea or the merit of a proposal because of who's making it to you. And that's what mediators do. They neutralize it, right? So I'll go talk to both sides, and then you come back and you say, well, what about this? And if it's coming from the third party neutral, the other party doesn't necessarily know who made it up, the mediator or the other party. And that's what Congress needs. And they can't. I mean, I'm a political junkie, and I've been watching all the debates, and it's just unbelievable. And I would love to do a Lee Ross game, which is take some very progressive Democratic idea and have one of the Republican guys propose it. And then my example of that as a former welfare lawyer is when President Nixon was president, he proposed a negative income tax. I don't know if any of you have ever studied that. And we, progressive, welfare types, did everything we could, and we were successful because Nixon had a Democratic Congress, and we defeated it. And as I look back on it now, decades later, I think it was probably one of the best substantive proposals for redistribution of wealth and poverty amelioration. It wasn't going to solve everything, but it was better than anything else on the table. And you would have gotten me or any Democrat to vote for anything that had welfare and Nixon in the same sentence? Never. That's reactive devaluation. So on some level, at the legislative level, the European countries that don't have two-party systems, they get more done because they have to form coalitions across issues. And give me a lot of parties, I'm much happier. A lot of parties, you can do interweaving and trades on different issues, and I think you actually tend to get, some people don't like there's more compromise and more mushiness in those, but I actually think you get more done. Jen?
We'll give the dean the last question.
Yeah.
I'd like to pick up on your point about charismatic champions or leaders, and
She's one of them.
and to the role of judges in the promotion
Yes.
of mediation specifically. What are your views on that?
Ah.
Because I think there are many people in the movement who get a little scared
Yep.
when judges become huge fans of mediation. But there also seems to be the reality that a judge who understands it can perhaps do more good than anyone. And I'd love to hear your views on that.
So I spent many of my years in Washington training federal judges at the Federal Judicial Center. And my answer is, I like it when judges are in favor of mediation for the right reasons, and I hate judges who become mediators. Gonna have to excise that from the YouTube, right? The worst students I just tell you, my best students were some of the most reluctant lawyers in these asbestos cases. My worst students was when the FJC had me actually training judges in mediation. I viewed my job as educating judges so that they could make proper referrals, about processes, not about people, and that they would know enough about it so that they would say to the right parties, maybe you want to think about mediation. What a lot of those judges, and I come from California, that's where JAM started. So a lot of judges said, oh, this is good, I can do this. And so they leave the bench and leave their $175,000 a year jobs so that they could make $400,000 or $500,000 or $1 million a year, some of them, as mediators. Pardon? Oh, and they're long enough they can keep their pension. Well, and do you guys know about Stay Fed here in Connecticut? Yeah. Okay. I was really I'm very proud. I think I helped defeat some of it. So the Stay Fed idea was that sitting judges would be allowed to moonlight at night as mediators, state judges and federal judges. So in California, they collect their pension, and they can't do both other than this rent-a-judge thing, which is sanctioned by law. So I appreciate, so for example, one of my heroes, Brock Hornby, he's a federal judge in Maine, in Portland. He was one of the judges I spent a lot of time with. He's great because he's a big proponent of describing to the parties what's available. And he does it from a place of saying the use of ADR increases access to the courts because people can get mediation services or arbitration if that's what they want, and get their dispute resolved, and then the cases will be left that the judges really should be hearing. So he's written a couple of short pieces in the federal judges' newsletters. He's one of my heroes. Jack Weinstein, I think, big cases, but also he wasn't scared of trying a case, and he worked hard. So Chief Justice Berger, who is doing it to get cases off of his docket, I have no use for that. But a judge who truly understands that in a particular case, this might be a good thing to do, I love it. And so I believe in educating judges. The two judges I just described in Belgium and Holland are off the bench now. They spent many years, so they have the gravitas And another one of my favorite people here in the United States is Marquette, former Wisconsin Supreme, yes, Janine Jageski. So she spent many years on the Wisconsin Supreme Court, and she is now, in my view, one of the leading restorative justice and criminal law champions in the country. She's amazing. I actually went to go to some of her clinic classes at Marquette, and I was just, she's a person as a judge who manages to bring victims and offenders, not that people are getting out, murders. They've done cases of murders. And in the case that really moved me, one family whose daughter was killed met with the young man who killed her daughter. He doesn't have a death sentence, but a life sentence. He may or may not get out eventually. That family is paying for his younger brother's education. Talk about restorative justice, because they said, you know, we can't bring our daughter back, and we want to be sure that this doesn't happen in your family again. So she's just a model of a charismatic post being on the bench judge who can do an enormous amount of work, and she's not making a gazillion dollars. She's doing it in a clinical setting. So I'm happy with that, and I'm happy with these judges in Europe who are totally off the bench. I get nervous about judges on the bench who are doing it for the wrong reasons, for docket clearance, and I also get nervous about the judges who are promoting it, and there are some, because they know that after promoting it they're going to leave the bench in 2 years, and then they want the cases. And my old hometown of Philadelphia has a lot of those. Anyway, so that's the last one. Great question. Great question. Thank you.
Thank you very much. I urge you actually to read the article if you have not read it. I didn't get to ask my question, we'll talk about it later, but one of my favorite was that there were Italy, where there was a heavy use of mediation. Right. Some of the bar went on strike because they were so upset with mediation. You know, so this has been a battle. The Turkish bar also been a big obstacle to the adoption of mediation in Turkey. So there's resistance in many places. It's interesting. But anyway, so thank you very much for coming, for doing double duty both at Yale and here at Quinnipiac. And thank you all for coming. Thank you, Society for Dispute Resolution, for leading the charge, and it's such a good turnout today. So thank you very much.
Thank you all.